Hey guys, welcome back to today's video. We've got a wild lineup. Two fools irritating the wrong judge, a pair of judges recusing themselves for very good reasons, and an update on our favorite chaos magnet, Eric Martin. We're kicking things off in Contempt Municipal Court, where one genius, out on bond for driving without a license, somehow thinks it's still fine to get behind the wheel. Buckle up, because this one's going to be a ride.
Look, Mr. Gregory, I'm not expecting for you to respond. I'm going to set this case for a pretrial conference on the same date as the other pending cases. You are facing a lot of jail time in these cases, and I don't want to hear any excuses from you today or at any time about why you're driving. I'm fed up with you! Constantly being in this courtroom driving against court orders while pending cases are happening. This is constant, well before Mr. Loftus was ever involved in representing you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you. And I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000 personal recognizance, not to operate or be in the driver's seat of another vehicle. Thank you, Mr. Loftus.
Can you see now why I actually enjoy watching this judge? He's fair, he's strict, and he runs his courtroom like an absolute boss. In fact, we're sticking around his courtroom for our next defendant. Now, here's the kicker. This next hearing is about to happen in front of a group of young kids on a courthouse field trip. And they're about to get a first-hand lesson in what it really means to be around and find out the consequences.
Okay, Ms. Sullivan, did you understand all of the rights and plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022. If you're not able to provide this court proof of insurance on the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean by non-political, whatever the fuck did you say? What did you mean by non-political, whatever the fuck did you say?
Take her into custody. Did you just use the F word in front of these kids? In front of me? Did you just do that? Take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids, and then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here.
Sir, come.
Get out of here.
Yeah, he didn't take her case back up that day, though it didn't really matter. She was there to turn herself in on a bench warrant anyway. Now, let's move on to our next case from last week in Judge DeSantos' courtroom. Things get a little wild here as the defendant starts throwing out accusations of racism left and right. But Judge DeSantos isn't having any of that nonsense.
Case number 25W700388, the state of Michigan versus Bradley Peterson. Okay, counsel, your Mr. Perpenwalk Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, name for the record, please.
Bradley Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably. And at this time, I would ask to be allowed to recuse myself from this case, Judge.
This is actually a pretty interesting situation. Usually, when a lawyer is removed from a case, it's the defendant doing the firing. We see it all the time in sovereign citizen trials, where the attorney refuses to go along with the defendant's outlandish delusions. The defendant then hopes the next lawyer will join him in his crayon-flavored lollipop world. But in this case, it's different. The disagreement is over legal strategy, and it's ultimately the defendant's right to pursue whatever approach he thinks is best. That's why it's the lawyer asking to be recused, probably because he doesn't feel comfortable putting his license on the line for the defendant's frivolous motions. I'm sure he also feels completely handicapped having to go up against the defendant's second legal team from the illustrious offices of Procedural, Dick Flut, and Dumbass.
All right, so counsel, you are asking to be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship, speaking-wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right, the court will note that there was a motion that was filed today asking for this court
For the videotape, hearing a bell and charges.
Okay, we don't have videotape. You can request a transcript, certainly. Yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, January 7th, when we had a bail bond discussion and charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't That was not recorded over Zoom.
Okay,
It
it was
was
just on
recorded
transcript.
on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts. You
Okay.
can just request the transcripts.
Okay, yeah.
There's a fee that you have to pay, but it's not a motion.
I honestly don't think it's in your best interest to be representing yourself, especially when you don't even know the proper procedure for basic things like requesting court transcripts.
If I request that. Also, I request on the Michigan Court Rule 2.003. I believe it's filed that on the 17th on Friday or something like that. So
Okay, hold on, just a moment. Okay, well, counsel, I will allow you to, I will grant your motion to, terminate representation specifically, as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course,
to-
I would ensure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. So the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
yes.
That's all of this one. You filed something on January 17, and you're requesting under 2.003 to dismiss, qualify the judge as follows. Filed the motion in good faith. The fair bond conditions and restrictions to stop U.S. public protests at the city of Winnebago Public Schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
Not
reading,
at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on me, specifically told them, case dismissed, that he cannot violate my constitutional right.
And that, friends, is a bold-faced lie. You see, I'm one of those rare content creators who actually digs into the case histories of the people I cover, especially when they make factually incorrect claims while conveniently citing exactly the proof I need to debunk them. In this case, he referenced Judge Grant in his suit against the city of Woodhaven, which led me straight to the federal case Brad Peterson versus multiple defendants in the Eastern District of Michigan. He literally sued the state of Michigan, the city of Woodhaven, the mayor, the presiding judge, and the prosecutor for civil rights violations. He claimed the city put out a PO on him, and while there's wording in the opinion that might suggest that the appeal he filed after losing tells the real story. Peterson's failure to object to the report recommending denial of his motion for an injunction permits the court to adopt it without further comment. However, the court agrees with the findings and conclusions in that report. That single statement says a lot while saying almost nothing. It confirms that Peterson did file a counter request for an injunction against an injunction aimed at stopping him from violating a sign ordinance in Woodhaven. It also confirms that even if he had appealed, the court would have ruled against him anyway. Magistrate Grant did dismiss several of his cases, but those were almost exclusively the ones he himself filed. The city's injunction against him remained in place, contrary to his claim. To wrap up this side story, in December 2024, the appellate judge issued a final ruling dismissing all charges against the state and its co-defendants with prejudice. So, seriously, stop lying. You're way too old for that.
Now, and I believe that's the issue.
Oh, hold on, please, just one moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir,
I'm with you.
the allegation is that you assault or resisted, obstructed a police officer causing injury and trespassed.
That's
Now,
just an allegation.
you're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they're allegations only.
Yeah, you need to read the whole thing of it, just one. I got like 15 issues in there.
15 issues.
Yeah, you
Okay,
need
so
to read the whole thing. Also, Your Honor, I publicly protested today in front of your court,
okay.
but none of your police came out to arrest me because that's my constitutional right to do.
You're
I'm
correct.
not ignorant of my constitutional rights. I'm not ignorant. A judge told me a long time ago, ignorance of the law is no excuse.
Right.
And so I studied a little bit. I don't know a lot, but I know my constitutional rights. I've done read your European Constitution over and over again. Actually, I wrote one of mine.
And I'm sure it's filled with plenty of stick figures and brightly colored construction paper. But who the heck cares? You can draft as many non-European constitutions as you want, but it doesn't change the simple fact that while you're in the state of Michigan, you're still bound by both federal and state law, just as the 10th Amendment of the U.S. Constitution grants to the state.
If I followed your white laws, I follow them, and then you stomp on me when I follow your laws. You've been doing this for hundreds of years. You know, Martin Luther King marched, and you guys took dogs out.
Stop right now.
You
I'm
violated
not
our
100 years
rights.
old, so do not accuse me of stomping on anything.
Well,
Let's be very clear on that.
yeah, well, okay, yeah, don't seem like it.
I'm not 100 years old, sir. Were you interfered with at all while you were engaging in your protest?
My constitutional right? No.
No, you were
I did
not.
at the city of Woodhaven though, and now you condemning me for it
No,
because
sir.
you restricted me.
Sir, let me be very clear.
I've committed no crime.
I am restricting, I put conditions on for the protection of the complaining witnesses, which is the authority that I've been given with my judicial discretion.
You also
No.
took an oath to uphold every citizen's constitutional right to public protest, but
Okay.
you're not doing that.
Sir, let me clarify. Let me clarify something. There is a balancing act that as judges we have to do. So we have you're charged with a crime, right? It's an allegation. We have the protection of the victim and the community. All right? So there's a balancing act that this court has to do. And that is what this court is doing. I have not restricted all of your movement. I have not said you can't put signs up anywhere. You can't go on any public property. I have not done that, sir.
You did.
No. What I did was I addressed specifically the complaining witness and the victims in this matter. That is what I did, and that is what I have the authority to do that's been given to me by the U.S. Constitution as well. That's statutory authority. Whether you agree with that or not, sir. I understand you don't agree, but that's not a basis for this court to disqualify itself. Let's see what the next one is here. Okay, I don't know what bias favors are. I'm not biased, prejudiced, discriminating against you in any way, sir.
That's your opinion.
And sir, let me just be very clear. The court has not infringed on your First Amendment right of free speech. What it did is it put in protections for the victim in this matter.
I'm the victim. I'm the
Which this
victim.
court has every authority to do.
I'm the victim, and you're not recognizing that. I just protested in front of your courthouse and it was okay. You should have arrested me then. When I go to your
So
schools
I don't
and your
have
wind
arrest
out,
warrants.
when I go to schools and your wind out, you should arrest me. But
Sir,
you're not going to. It's
I
not
do
right.
not.
This guy is such a professional victim that he's actually in the courtroom arguing with the judge about why they didn't arrest him for exercising his constitutionally protected rights.
Let me just clarify. I, as a judge, do not have the authority to arrest you myself.
Well, they don't either. They took an oath to uphold my civil rights, whether they like it or not.
Sir, did anybody arrest you here?
You weren't supposed to. It's my constitutional right to do. Just like in the city of Woodhaven. This is what I'm trying to get through to you. You're trying to say, no. There's allegations against you that you did this, and this. I'm trying to tell you I exercised my constitutional rights and they violated me. I'm the victim.
And sir, that is everything that will come through discovery and whatnot. At this stage, this is considered pre-trial.
I know what this is.
So
I've been through your system before.
So
also, Your Honor, I've asked if you don't dismiss yourself, I'm asking for another judge to hold.
Just one moment, please. This court, sir, has to take the allegations and there's a process.
Like I don't know it. I know your process. I've been down your roads before. But
I don't know
I'm
what
15.
roads of mine you've been down, sir.
I'm 15,
But you've
the
been here,
defendant-
excuse me, you've been here in this court a number of times
Yes,
as
I have.
other matters have been disqualified.
Yes, I
And you
have.
have been treated with respect and fairness. And I believe you've even
That's
stated that
not
yourself.
all entirely true.
Hold on, sir. I believe you've even stated that yourself.
Yeah, but that's not all entirely true. You wasn't here to dismiss the posted signs, was you? You should have been here when the prosecutor dismissed City of Woodhaven posted signs.
What?
You didn't show up then.
Hold on, sir. I don't even know what one that is you're talking about.
Well, there was the one that we was going through and postponed. The City of
that
Woodhaven
the
wrote
federal one?
violation. No, they wrote violations on me for posted signs in this case. In other cases. Because I was protesting in the City of Woodhaven.
Okay.
But on that, the day that you were supposed to be here to have that case dismissed, another judge took your place. You think I'm sleepy or stupid? I'm not. But I'm 15.
Stop there right now, sir. Stop there right now. I don't think you're sleepy and I don't think you're stupid. When was that case? The one that you're talking about that I had another judge sitting for me, when was that case?
That was, I don't know the exact date of it, but I know the case was dismissed by a prosecutor.
Was that about a year ago, sir?
It was last year.
Last year.
Yeah.
Okay, well, the time that I had somebody sitting here in my place was because I had to go to Illinois on an emergency basis because my father had a stroke.
Oh, my fault.
So instead of having everything dismissed, I made sure I had another judge here to cover. So do not accuse me of thinking that you're sleepy or stupid.
You can go ahead and accuse me, Your Honor, because, honestly, I think he's equal parts sleepy and dumb as a rock.
I made sure that there was a judge here to cover it anyway. So whether I was here or not is irrelevant.
The case got dismissed from the City of Woodhaven. But anyway,
That's
I'm 15. The defendant under Michigan Court Rule 2.003 requests a hearing by a district court chief judge in case if judge refuses to dismiss herself from this case. I know I have a constitutional right. If you don't dismiss yourself, I have the right for another judge to look at it. This way, it's impartial. It's where another judge can look at it and not just yourself. And apparently, you want to hold this case for a reason. And I believe that you in the City of Woodhaven, the state of Michigan, is in conspiracy. You know what I mean? You guys can say I'm crazy or not, but that's what I'm seeing. Because if you're fighting so hard to keep this case in your court, there's something wrong. Something got to be wrong. You already violated my constitutional right to public protest at the City of Woodhaven because of allegations that I committed assault against the police officer. You guys don't even know me.
Sir, okay, stop right there, please, just one moment. So, I'm not fighting to hold on to this case. I was assigned this case by the State Court Administrative Office. Now, I'm also elected to preside over cases. So, unless there's a valid reason for this court to disqualify itself, I am obligated, whether I want to or not, to sit and preside over the matter. I am the chief judge of this court, and so I don't find that there's a basis at this point for me to disqualify myself. However, you certainly have the right to request the State Court Administrative Office can review that. That is absolutely your right. That's how that gets reviewed.
Well, yeah, I want another judge to look at this because if you don't want to dismiss yourself from this case, we got a problem right there. Because
There's no problem, sir. I have a responsibility.
The city would have.
Sir, I have a responsibility. The matter was transferred over to the 27th District Court because the 33rd District Court disqualified itself. Perhaps they sent it here because the other matters that you've had here I don't know. I can ask for the case to be sent here. It's random. I have zero, just as though when I disqualify myself from a case, it gets sent somewhere else. I have no control over where it gets sent. I have no control over what gets sent to me, whether it's from 25th District Court, 28th District Court, 24th District Court, 34th District Court, or the like, sir.
Well,
So,
I have history.
just so you're aware.
Well, I have a history of this 27th District Court in cahoots with the city of Woodhaven. I think the judge Ken Bash or something like that. He might be up there somewhere. He's retired now. You guys did me the same thing, same way you did.
You guys, I wasn't here.
Well,
It's not her system. It's our system. We the people elect legislators to create rules and regulations that everyone agrees to follow the moment we start enjoying the benefits of society. You might not like the system, but it's not built to satisfy individuals like you. It's designed to govern all the citizens living under its jurisdiction. And if you really don't like it, well, you're free to leave anytime.